The Senate will come to order. Mr. Carpenter, please call the roll.
Senators Bridges, Cook, Quorum, Crowder, Danielson, Donovan, Finberg, Fields, Foote, Gardner, Janal, Gonzalez, Hanson, Hill,
Excused.
Heisey, Holbert,
Excused.
Lee, Lundeen, Marble, Moreno, Pedersen,
Majority Leader.
Excused.
Briola, Rankin, Rodriguez, Scott, Smallwood, Sonnenberg, Story, Tate, Todd, Williams, Winter, Woodward, Zinzinger. Mr. President.
Here. With 32 present, 0 absent, and 3 excused, we have a quorum. Senator Marble, would you please lead us in the Pledge of Allegiance?
Thank you, Mr. President. Colleagues and guests in the gallery, please rise and join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Adoption of the Journal. Senator Rodriguez.
Thank you, Mr. President. I move the reading of the Journal for Wednesday, February 5th, 2020 be dispensed with and the Journal be approved as corrected by the Secretary.
You have heard the motion. All those in favor say aye. All those opposed, no. The ayes have it. The motion is adopted. Mr. Carpenter, please add the Minority Leader to the roll call. Senate Services.
Correctly printed, Senate Joint Resolution 7, 8, 9, 10, 11, 12, and 113. Correctly engrossed, Senate Bill 37 and 61. Correctly enrolled, Senate Resolution 2.
Committee reports.
February 5th, 2020, Committee on Education, after consideration of Mayor's Committee as following. Senate Bill 23 be amended as follows as so amended, be referred to Committee on Appropriations with a favorable recommendation. February 5th, 2020, Community Health and Human Services, after consideration of Mayor's Committee as following. Senate Bill 87 be amended as follows as so amended, be referred to Committee whole with a favorable recommendation. February 5th, 2020, Community Health and Human Services, after consideration of Mayor's Committee as following. House Bill 1056 be referred to Committee whole with a favorable recommendation. Recommendation placed on the consent calendar.
Members, would you please join me in welcoming back to the chamber our good friend, former President Bill Cadman. President Cadman, it's important to note that we will not be showing the video on the chamber restoration at the end. Third reading of bills, consent calendar. Mr. Carpenter, will you please read all the titles of the bills listed on the consent calendar?
Senate Bill 37 by Senators Rodriguez and Fields and Representative Singer concerning the development of a strategic plan to implement a trusted interoperability platform.
Mr. Majority Leader.
Thank you, Mr. President. I move for the passage of the bill in the third reading of bill's consent calendar, which includes Senate Bill 37.
Is there any discussion on any of the bills, including Senate Bill 037, Seeing none, the motion before the body is the passage of Senate Bill 037 on third reading and final passage consent calendar. Are there any no votes? With a vote of 33 ayes, Senator Marble.
Thank you, Mr. President. I wish to be recorded as a no vote on Senate Bill 37.
Senator Marble will be recorded as a no vote on Senate Bill 37. With 32 ayes, 1 no vote, 0 absent, and 2 excused, Senate Bill 037 is passed. Co-sponsors. Senator Lee. Third reading of bills, final passage. Mr. Carpenter, please read the title to Senate Bill 061.
Senate Bill 61 by Senator Foote and Representative Becker concerning requirement to yield to a bicycle in a bicycle lane.
Senator Foote.
Thank you, Mr. President. I move Senate Bill 61 on third reading and final passage and ask for an aye vote.
Is there any discussion? Senator Gardner.
Thank you, Mr. President. It is tempting in rising in opposition to this bill to take a full 10 minutes this morning, particularly since I have a group from the Resource Exchange in Colorado Springs this morning. But I will confine my comments and remarks to the reason for my no vote. This is an important bill. It is a bill that clarifies from a traffic regulation standpoint who has the right-of-way as between a vehicle and a bicycle in a bike lane. And as far as that goes, that is important, and we need to do that. What is disappointing to me, and the reason that I am no vote, is that rather than imposing then a traffic penalty and really, in essence, in some cases a civil penalty, other cases a criminal penalty, as we would for a vehicle-to-vehicle or vehicle even to pedestrian kind of right-of-way situation, we have made a special case out of bicycles and other users of bicycle lanes. That is a bad trend. That is something I've consistently objected to here in the General Assembly, and for that reason I will be a no vote.
The good senator from El Paso County will be fined $4 for referring to guests in reference to Senate Bill 061. Further discussion? Having no further discussion, the motion before the body is the passage of Senate Bill 061 on third reading and final passage. Are there any no votes? Mr. Minority Leader, Senators Gardner, Cook, Smallwood, Crowder, Lundeen, Sonnenberg, Marble, Scott, Quorum, Woodward. With 22 ayes, 11 no votes, 0 absent, and 2 excused, Senate Bill 061 is passed. Co-sponsors, Senators Gonzalez, Danielson, Lee, Winter, Story, Hanson, Janal, Bridges, Williams, Priola, Todd, second reading of bills. Consent calendar. Senator Zenzinger.
Thank you, Mr. President. I move that the Senate resolve itself into the Committee of the Whole for consideration of general orders, second reading of bills.
You have heard the motion. All those in favor say aye. All those opposed, no. The motion is adopted. The Senate will resolve itself into the Committee of the Whole for consideration of general orders, second reading of bills, and Senator Zenzinger will take the chair.
The committee will come to order and the court rule is relaxed. Will the clerk please read the title to Senate Bill 93?
Senate Bill 93 by Senators Foot and Finberg and Representatives Jackson concerning protections related to mandatory agreement provisions in connection with enacting the Consumer and Employee Dispute Resolution Fairness Act.
Well, we can talk about it, and then we can do a 5 minute
Senator Foot.
Thank you, Madam Chair. Members, we are discussing here this morning Senate Bill 93, which is the arbitration bill, and we're happy to bring this bill before you for your consideration because what it's about at the end of the day is a fair arbitration process. I think everybody in this chamber knows that the arbitration process is a process that's designed. Excuse me, I'm sorry, Madam Chair, may I move? I move Senate Bill 93.
And the committee reports?
Right, and the Judiciary Committee report.
Thank you. To the report.
Thank you, Madam Chair. Okay, so the Judiciary Committee report reflects 3 amendments that we put on in committee. One thing that I'll note is that we've said from the beginning with those that have concerns about this bill that we're listening to their concerns and we have adopted a number of amendments already in committee, and we will be proposing some amendments here on the floor as well that address some of those concerns. And so 3 amendments that we moved and were accepted by the Judiciary Committee include one that deals with trade organizations and those that are designated as 501c6 organizations under the IRS code, and they are exempt from the bill just like other organizations are. The reason being is that when you have an arbitration process and you have 2 organizations that are on equal footing, that are on the same playing field, that are level, then that's not the kind of agreement that we're looking to address here. We're looking to address instead agreements that are those from an unlevel playing field, from one power that has an imbalance of, or one interest that has an imbalance of power over the other. And so we took that part out, or we made sure that those were exempted. We also struck some language that was considered by some to be overbroad that deals with the ethics under evident partiality. And then third, we also amended the attorney's fees provision in order to get rid of a section in there that would have awarded attorney's fees related back to if an arbitrator did not disclose what they're supposed to disclose. And the argument was that if it's the arbitrator's fault, then the attorney's fees shouldn't be awarded because of something the arbitrator did or failed to do that they should have done. So those are 3 amendments we discussed and we adopted in committee, and we asked for an aye vote for the committee report.
Is there any further discussion on the committee report? Seeing none, the motion before the body is the adoption of the committee report. All those in favor, aye. Any opposed, no. The ayes have it, and the committee report is adopted. To the bill. Senator Foot.
Thank you, Madam Chair. I promise that I'll get this procedure right here sometime in the near future. So we are now talking about the bill. We're talking about the arbitration bill. And really, I'm sure we'll be discussing a lot more as the time goes on this morning. But what I hope that you'll keep in mind is that this bill is designed to make sure the arbitration process is fair. Arbitration is an alternative to court. It's a good alternative to court. It's something that's designed to be fast and efficient. And in this case, we want to make sure it's also designed to be fair. And so there are a number of provisions in the bill that are designed to make that process fairer, particularly for those that are not on the same playing field as another party. So if you have an employer versus an employee, that's not necessarily a level playing field, but we want to make sure that it is if it goes to arbitration. If there's a corporation and a consumer, they are not necessarily on the same playing field. We want to make sure that they are when it comes to arbitration, because if arbitration is to be an alternative to court, and it is, then it should also be fair, like a court process. And we want to make sure that everybody's on a level playing field. They get a fair hearing. That doesn't mean they're going to win. It just means they get a fair hearing. And that's what we're after in this bill, and we hope that you'll support it.
Majority Leader Finberg.
Thank you, Madam Chair. This is an incredibly important concept, and I would say an incredibly important bill. And that's Really, because it literally touches the lives of every single person in the state of Colorado. This is something that I think no matter who you are, as you go through your day, you probably are agreeing to arbitration. Whether you know it or not. It's in a user agreement that you clicked accept on, or it's in an employment handbook that you signed and agreed to, or something else. This is something that touches every consumer, every employee, every business, every employer in the state of Colorado. There is, the senator from Lafayette said there are going to be several amendments. Obviously, because this touches every industry and every individual in Colorado, there are a lot of people interested in making sure that it doesn't have any unintended consequences, and we are committed to working through that. And that's why there have been several amendments, and there will be several more coming. But I do want to make sure people understand the basics of what this bill does. And forced arbitration is something that we're going to be talking about. This bill does not get rid of forced arbitration. All it simply does is create a basic code of conduct and some ethical standards for when forced arbitration occurs. It does three things. It sets up a basic ethical code of conduct that is very similar to what a judge has to follow in a court. It requires public disclosure of some basic facts of a case, just like how a court discloses those same similar basic facts of a case. And it clarifies what can or cannot be included in what is called a standard form contract, such as requiring that one party unilaterally choosing the arbitrator. Normally, in a court, one party would not be able to choose the judge unilaterally. But it also says that you can't require arbitration to occur hundreds or thousands of miles away from where that dispute arose. These are basic standards that actually several other states have already implemented different versions of it. I am confident that this is going to not take away this option for employers, employees, consumers, businesses, but instead just make sure that there is fairness and basic transparency when arbitration is used to settle a dispute outside of a courtroom. I'm sure there's going to be plenty of debate, so I will vacate and we can get started.
Senator Lundin.
Thank you very much, Madam Chair. Appreciate very much the effort that the bill sponsors are bringing and the stated goals of what the bill sponsors are bringing. I'm confident that as we walk through this 20-plus page bill today, we're going to see that, in fact, the complexity that is inherent in this bill may not, in fact, achieve exactly the stated goals. So at issue is this question: how many of you have been involved in a complex lawsuit, something that required lawyering up on both sides? A lot of expense, a lot of detail, a lot of pleadings, a lot of briefs, a lot of action. It's not a pleasant experience. How many of you have been to small claims court? Small, simple issue, a few $1,000s, things aren't going right. You have the opportunity to plead before a judge, person to person, and having a logical opportunity to have the conversation about what actually happened, what are the facts, what should happen. A considerably simpler process. There is established in the way we manage our society and manage our business relationships today an even simpler process. It's called arbitration. It's where individuals who have a disagreement have the opportunity to sit down in a calm way with somebody who may or may not have some expertise in the area of dispute, excuse me, and say, here are the facts. Here is what is at issue. Here are the things we care about. Here's what you care about. And how can we find a simple pathway forward? Quite frankly, it saves all of us an enormous amount of time and effort and energy, this thing called arbitration. And occasionally, we're hoping somebody in the chair helping us arbitrate, helping us understand what's going on, is somebody who actually knows a little bit about the specific subject areas in which our dispute may have arisen. I will tell you, this bill, as drafted, right now, coming out of the committee with the committee report, is so far overreaching as to kill the arbitration industry, to take away from all of us that simple matter of getting to a resolution without having to lawyer up. Now, if you're in the business of being a lawyer, lawyering up might be a good thing. And I would argue that should this bill pass, coming to a courtroom near you soon will be a lot of lawyers doing a lot of work, taking a lot of your money, disrupting so much of what we do in a simple way right now through arbitration. Because this bill, as constructed, is going to chase so many who currently provide the service of arbitration out of the business. It just will not make sense to them to climb over the high wall, the high barrier, the effort, the disclosure. You know what? I got to build a new website if I'm going to be an arbitrator now. I've got to disclose things from my childhood history. Okay, I exaggerate. Maybe not my childhood. But the reality is the requirements of disclosure, the requirements that are designed to push people out of this business, to kill this idea, this simple idea that gives us all an easier pathway to resolution when there's a dispute, would in fact, as opposed to the stated purposes of this bill, saving and sustaining a fair process, stated objective. Ultimate result of this bill, the exact opposite. Creating a level playing field on behalf of both participants in a dispute. DOA with this bill. So I start with these very broad comments that call into, I think, vital and accurate question: what happens to the arbitration industry should this bill pass? It is my considered opinion it will be hobbled, hamstrung, or perhaps outright destroyed. And that redounds to the cost of all of us and damages us in a material way. Madam Chair, I will have other comments as we get into the details of this, but I wanted to be really clear in the framing. Level playing field? Heck yes. We all want a level playing field. Fair process? Heck yes. We all want a fair process. But sometimes fair requires simple. And this bill will ratchet up the required complexity to get to resolution. Madam Chair, I rise in opposition, as you might hear more than once today, to Senate Bill 93.
Is there any further discussion? Senator Gardner.
Thank you, Madam Chair. As I listened to my colleague, the senator from El Paso County Monument, as a lawyer, I was becoming quite excited at the economic prospects for my little country law firm down in Colorado Springs. Or I would have, except for one thing. Let me ask all of you here, I know you're all paying rapt attention as my friends from Colorado Springs that are with us here this morning are paying rapt attention. I'm sure all of you are as well. Let me ask you a question. How many of you have perhaps had occasion to draft an arbitration clause, say, in the past 90 days? Anybody done that besides me? The senator from Douglas County has actually drafted an arbitration clause in the past 90 days. I'm surprised but gratified to hear that someone with actual experience with arbitration clauses and why you might choose to do that is present with me here today. How many of you have had an occasion to serve as an arbitrator? Anybody served as an arbitrator besides myself? And how many of you have, and I may have a few more people, how many of you have either represented a party in arbitration or been a party in an arbitration? Anybody? Two or three? That's why it's great to have a citizen legislature Occasionally, we actually have some people with experience in what we're legislating on. So let me tell you about the drafting of arbitration clauses and the use of arbitration as I encounter it in my law practice. You know, I don't represent, in my small law practice, I don't represent Fortune 500 companies. I don't represent huge businesses with imbalances of power against someone else. As often as not, I'm representing the party against the Fortune 500 corporation. And because they have unlimited resources, sometimes I want to choose an arbitration clause for my client because I want to be able to get them to a dispute resolution proceeding of some sort with some hope of not being so over-lawyered on the other side that they get buried in paper. Now, when I first came to the legislature, there was a rumor that I read every bill. I don't want to spell that. Really what I did was I mastered the art of reading the first page and the definitions in a bill. Sometimes you can decide whether you're for or against a bill just by reading the definitions. And in this bill is portrayed as a bill that will help all the little guys against the big guys. And so it has a definition of consumer. Now one of the things that's really neat about the law and statutes is that you can define a word as anything. You can use the word orange in quotes under definitions and then proceed to say that an orange is an orange, a tangerine, and maybe even an apple. So here we have consumer. And consumer, it's in a couple of places in the bill. It means a claimant that obtains, maintains, uses, purchases, leases, or has standing to assert claims relating to goods, services, or real or personal property used primarily for personal, family, residential, or household purposes. Well, I represent some small construction contractors, folks who redo people's kitchens, people who put roofs on houses, not the people who show up after the hailstorm, but the people who actually live in El Paso County and do those services. And they often ask me if I would do a standard purchase order for them, standard contract, because they go out and they meet with people and they decide whether to take on a job. They're just regular folks themselves. And I often say, you might want to have an arbitration clause in your contract. And they say, well, why? And then they will tell me their horror story about going to small claims court. And I say, well, that's the reason you might want to have an arbitration clause. You could agree, and there are 2 or 3 major arbitration services in Colorado. I won't call their names from the well. Attorneys know who they are. There's 10 or 12 other smaller groups, and they all have multiple arbitrators. And the way you choose an arbitrator most commonly is you get a list, and it's a little like jury strikes. Anybody ever served on a jury and been one of the people stricken? You say, these are the people I'll take, and the other guy says, these are the people I take. We even have a provision, sometimes it says when you can't agree on an arbitrator, each party will choose each party will choose an arbitrator, and those two arbitrators will choose another arbitrator, and then they're out of the deal. We are told that this bill is about all of those mandatory arbitration provisions that many of us, I as well as you, sign up to when we click the box or get a credit card or a number of other things. And if that's what this bill was about, and it was only about that, I'm not going to be disingenuous with you, as some sometimes are here in the well. I'm not going to say, well, I'd just be right on board and I wouldn't have anything to say about it. But I have to tell you, I get it, because I'm one of those consumers just as well as you are, and I sign up to those things, and I know more than most of you when I'm signing up to them that that's really a very large company selling services to hundreds, thousands, and millions of us, and if I don't want to do it, they don't need to sell to me. That will be the reaction. So I get that one, but that's not what we've done here. We've gone into all of those actually negotiated arbitration provisions, those between small business people and regular consumers. Now, we may have an amendment to offer later about that, but as we begin this discussion, I don't want there to be any confusion that this bill is just a consumer bill. It goes much more broadly than that. And it requires arbitrators to, those who would engage in arbitration services, to disclose, as the senator from Monument talks about, lots more. I mean, it's very disturbing to me. One of the things I've thought about when I have a bit more time in my law practice, and you see attorneys do this as they advance through their practice, they create an alternative dispute resolution practice. They do mediations and arbitrations. They offer themselves up. And it turns out that there's quite a market for attorneys who can deal with esoteric subjects. And I don't know if I'll be able to be marketable in dealing with esoteric subjects. Hard to say, but when I say that, I mean computer software, engineering topics, and things like that. And there are a lot of single attorney arbitrators who have their own call it a simple country arbitration practice. But this bill is going to apply to them as well. It is going to regulate them out of business, frankly. This is going to be very, very good for the large arbitration practices in one way, like so much regulation is. It's, whenever we regulate anything, the large players in any industry come in and they object, and they populate the lobby back there. And sometimes they're successful, but when they're not, one of the interesting things about it is they tend to survive, and the little folks that were standing next to them, the small businesses engaged in that industry, tend not to survive. You see that in banking. You see that in real estate. You see it in almost every industry. We regulate them out of business. That's what this will do to the small independent arbitrators, the ones that we actually want to encourage to be in this business. I think many of you already know that there are important associations and groups that are opposed to this bill, and I'm not talking about big Fortune 500 companies. I'm talking about the Bar Association, which has lawyers of all types. Why? Because this bill is not good for dispute resolution. It is too broad. It does far more than it claims. It raises all sorts of issues that have not been addressed. Let me leave you with one more, and I will yield the floor to other colleagues to speak for a few moments. You know, this bill also applies in the employer-employee context. And again, I get that. Now, I do a lot of employer-employee contracts, but I tend to do them for a single executive with a mid-sized business. And that's a negotiated contract. It's not a contract that the prospective employee has no bargaining power or can't do anything about. It's a level playing field in that sense. But there are contracts with large national employers that employees have to sign up to. If you want to work there, you've got to agree to arbitration. And I could honestly understand if the issue was, how do you ensure that the arbitrator who arbitrates that dispute is a neutral arbitrator, a neutral third party? That's an important thing. But just so you know, folks, how many people know that there's something called the Federal Arbitration Act? Anybody? Some of us know this. Federal Arbitration Act that sets standards for arbitrators. Now, because of the Interstate Commerce Clause, it applies across the country. It doesn't apply to just federal disputes. It applies to disputes in interstate commerce. And those of you who are familiar with the court cases of deciding what is interstate commerce, particularly in the civil rights area, know that interstate commerce is just about everything. There are court cases saying selling a bushel of wheat to somebody down the highway from you engages in interstate commerce, and the reason for that is it affects the whole grain market in some small way. So the employment market, if you will, affects interstate commerce. Whether people are working here in Colorado or not working here in Colorado, that affects interstate commerce. And so the Federal Arbitration Act applies to these employer-employee contracts. And the Federal Arbitration Act has a whole different set of standards that are much more in common with Colorado's own Arbitration Act. In fact, you can square them up. I don't spend a lot of time, again, as a simple country lawyer, I don't spend a lot of time going, well, is that okay with the Federal Arbitration Act and the Colorado Arbitration Act? Right now, they mesh pretty well. Not so when we get done here. Now, as is so often the case, this bill seems to be following the example of California. How many of you would like to follow the example of California? I'm taking my hand down really quick. You need to know that just in the last week, that a federal district judge in California blocked an arbitration ban, what is in essence a bill that really doesn't go as far as this proposed legislation. The judge blocked it because it was a violation of the Federal Arbitration Act, because the Federal Arbitration Act is based on interstate commerce. And so there was an employer and employee arbitration clause. The employee said, I don't have to go to arbitration because California's law, or at least there was a prospective situation like that. And the judge said, California law must yield to the Federal Arbitration Act. Now, we can all talk about the 10th Amendment some other day, but the reality is that under the Supremacy Clause of the Constitution, this legislation that is proposed here may well be a violation of the Federal Arbitration Act, and it may have to yield to that. Now, I always tell my constituents that, with tongue-in-cheek and irony and, frankly, sarcasm, that there's always good news for me at the Capitol because I'm a lawyer. And if this bill passes, there's some good news for me as a lawyer. It's bad news for my clients. It is really bad news. And for me as an attorney representing them, I consider it bad news. But the good news is there'll be a lot of work for lawyers. This is the full Legal Employment Act of 2020. But I put my constituents and my clients ahead of myself. And I oppose this bill. We will try to have some amendments. But I have to say, colleagues, this is far-reaching, ill-considered. It destroys so many business expectations that you, no matter which side of the aisle you stand on, you have constituents that are going to be negatively affected. I would encourage the sponsors to either make this a much narrower bill or bring a different bill, one that really is focused on the small consumer, the single employee, and not wipe out what is legitimate dispute resolution, which avoids courthouses, lawyers, and legal fees and cost. I ask for a no vote.
Senator Lundin.
Thank you very much, Madam Chair. So the way we do our business here is so very, very important. Process matters. It's quite frankly how iron sharpens iron, how that which leaves the building in terms of the black words on white pages and red books known as the CRS, Colorado Revised Statutes, gets better by virtue of the conversation. The process matters. I'm going to make 2 points about the process here. I'm looking at a document that was designed for conversation to feed that process, and it has 14 different suggestions how to narrow this bill. Now, you heard the previous speaker, the good senator from El Paso County, call out the fact that in California, a narrower bill that probably is subject to a few of the suggested amendments that we have offered up as possible conversation pieces for this bill, that narrower bill has been held up not once but twice by the judge, U.S. District Judge Kimberly Miller in the Eastern District of California because it's in conflict with the Federal Arbitration Act. So it's almost certain that this broader bill would run afoul of the same federal act. And so the 2 points I'm making with regard to process are, one, we've suggested up for the purposes of conversation, for making a better, narrower law, 14 different ideas that would be amendments that might improve, narrow, get towards something that might be livable, might not decimate the the arbitration industry the way this bill would as constructed. Now, the sponsors are under no compunction, no compulsion. They do not have to do anything, say anything, don't even have to respond to the fact that we're saying, hey, got 14 ideas. Would like you to look at them. Can we talk about them? They don't have to talk with us. But if iron's going to sharpen iron, if we're going to craft better policy, we need to have a conversation. There's a little bit of activity going on where it feels like we're trying to negotiate with a microphone held to our head. And the challenge is, it would be nice to actually be able to have a conversation that says there are big, big challenges within this. That's process challenge number one. We're not really working well with each other on shaping this bill in an important way. Process challenge number two is what the senator from El Paso County pointed out, and I mentioned. I think we're flying into a spider web here that is known as the federal law. U.S. District Judge Kimberly Miller of the Eastern District of California previously granted a TRO, a temporary restraining order, against a narrower bill in California, Assembly Bill 51, Friday the 31st of January, so very recently, just a week ago or so. She granted a preliminary injunction. This judge is climbing this wall of stop. No, I really mean stop. Bad bill running afoul of federal law. And she is saying with increasing vigor to a bill that is narrower than this bill, stop. It is not going to work. It is, in fact, in conflict with the Federal Arbitration Act. Now, those two process pieces are meaningful and material. And we should do a better job of interacting to see if we can't maybe consider broadly, is a time after this has been settled out with other law that is being considered across the country that would inform our discussion where we could actually get to a sustainable, livable law here in Colorado. Would it make sense for us to stand down and wait for that, point one? Point two, if not, then can we consider some of these many different ideas that have been offered up to narrow this particular bill and maybe make it better? For example, one of the proposed amendments speaks to 4 pages of the bill. And what this is 2-3 pages of data that is required to be disclosed by arbitrators if they want to stay in business, that puts not one target on their forehead, but it puts a target on their forehead, it puts a target on their back, it puts targets all over them. They have to give up so much information that it would be an incredible burden for them to compile the information. And then once that information is compiled, they have to make it public for the purposes of, not that anyone would ever do this, but it puts in one place all the information necessary for someone who wanted to pursue and take legal action against these individuals. It just does the homework. It does the research.
Senator Lundin, could we keep to the bill and
Yes,
not amendments unless you do...
Page 9, line 23 of the bill.
Great, thank you.
Arbitration service providers in consumer and employment arbitrations, public disclosures. The bill requires an arbitration service provider that administers arbitrations of consumer disputes or employment disputes shall collect, publish at least quarterly. So it's not like you got to get this together and you got to publish it, which is a burden. Any of you in business, any of you, whether the business is large or small, that have ever had an audit, you got to put a whole bunch of information together just to get through that audit. This essentially says stand for an audit every quarter of your existence. So you've got to publish at least quarterly and make reasonably available to the public for no charge on the website of the arbitration service provider. So you got to create a website if you don't have one. If any, and in writing upon request, a single cumulative report that contains all of the following information. Settle in, get your popcorn. The list of required information is enormous. Regarding each consumer or employment arbitration administered. So look back through your history, including those conducted by the provider within the preceding 5 years. You got to look back 5 years. How many of you, well, the reality is we all kind of wish that everything except tax returns, we could just get rid of it after 3 years. This says you got to keep a record, you got to look back over 5 years. Information required to be provided: the name of the non-consumer party or employer, whether the non-consumer party or employer initiated the arbitration or was the responding party, if known. B, the nature of the dispute involved, categorized as one of the following: goods, credit, other banking or finance, insurance, healthcare, construction, real estate, telecommunications, including software, internet usage, debt collection, personal injury, employment, or other. Whether the consumer, non-consumer, employee, or employer party was the prevailing party. So you got to disclose whether you won or lost. The total number of occasions, if any, that the non-consumer or employer party has previously been a party in an arbitration administered, and it goes on like this, requiring information about everything in granular detail of the business of the arbitrator. Burdensome, and there is potentially an intended or unintended, I will be charitable and say it's an unintended consequence. It potentially invites class action activities against these people. You can just go back, look through the data, and say, let's go get this group. As a group, let's sort through this data and cause mischief. So there's an enormous call for mischief in that. So that's just one challenging, troubling, easily fixable, should we be able to engage in a conversation, portion within this particular bill. So 2 points on process. We know, based on what's going on in California, the U.S. District Judge has said, stop. Not right, not ready for prime time. And 2, we're not really getting to, can we make this better? What do we need to do to adjust? How can we get to better in this particular bill? There are elements of this bill that I think will shake the foundation of fundamental elements that we, over the last couple of years, have come to understand as our reality. And I do not know that I've got my notes here on this. Let me speak to this just at a high level, and then we can come back and deal with it in more detail. We have an affordable housing problem in Colorado. Now, the problem isn't as bad today as it was a few years ago. And part of the reason why it's not as bad as it was a couple of years ago is we got to a negotiated bipartisan agreement around construction defects. And the reality is that is critical, because having a predictable, understandable playing field is critically important to insurance companies. Insurance companies manage risk. Insurance companies hate risk. Insurance companies do not like unpredictability. They like to know what's going on so that they, in fact, can say, yeah, there's an exposure, there's a potential risk here, it's going to cost us approximately X dollars to manage that, so we will underwrite those who are in a certain element of business. The insurance companies. The element of business that they underwrite, because it is critical to the success and the ability for this business to move forward, is home building. When you buy a home, a significant portion of the cost of that home is the calculation that people are making behind the scenes, not on how many feet of pipe is in the plumbing or how many square feet of drywall is in the walls. There's a calculation about the risk of lawsuits associated with that home being delivered to you. And when that becomes unpredictable, that cost goes up dramatically. That was part of the problem with affordable housing in Colorado. We dialed it down, and we have had an expansion over these last few years in home building because we have a more predictable environment, easier for insurers to underwrite, easier for developers to develop and build, easier for people to put a roof over their home. An unintended consequence of this particular bill would, in fact, be to remove that stability, to remove that predictability, which has helped us get a handle on, get our arms around the affordability of housing challenge and problem we have had in Colorado. So one example of an issue that you wouldn't think this is a forced arbitration bill, it's about helping the little guy. what could that possibly have to do with affordable housing? It's fundamental to affordable housing. So that is one example of the sorts of disruption that this particular bill, if not narrowed, if not improved, in fact, will have in the economy of Colorado, and quite frankly, in the ability of people in Colorado to afford to put a roof over their head. Not something we should be doing here. Let's continue to make it more affordable, not less affordable, for people to put a roof over their head in Colorado. Madam Chair, thank you.
Senator Danielson.
Thank you, Madam Chair. Thank you, colleagues. I just want to speak to why I support the measure today and urge you to vote yes on Senate Bill 93. What we're really talking about are the consumers across the state that we do represent and their ability to be treated fairly in a process when something has gone wrong. And I believe that it doesn't matter if we're talking about someone who has been wronged in an employment agreement or with their child care facility or a nursing home where they have to fight the system for someone who has abused their loved one. How many of you are in cell phone agreements? Have you read the fine print? What happens when you've been stolen from and you need to go and collect on it? Well, a lot of that is predetermined for you. And when you sign an agreement that binds you into arbitration, you're signing away a lot of your rights. And I don't think a number of us understand that when we get into these agreements. And they do a very good job of hiding them from you, in my experience at least. So whether you're fighting the nursing homes or you are a homeowner fighting for the home that you bought that has problems, we're talking about the rights of the consumers. And most of us can speak from experience in being on the other side of this fight. It's tough. The problem with forced arbitration is that you're not in front of a judge. You may or may not get an arbitrator who's neutral. You may or may not get an arbitrator that follows ethical standards. You may or may not get an arbitrator that does not have a conflict of interest. These problems are fairly common, and it's why the deck is stacked against the consumer. This is a measure that protects the people that we represent every day in so many different ways, to give them a leg up when they're trying to fight for their rights, when something has gone wrong, to help them operate under a system that's fair and balanced and without conflict of interest, with ethical standards that are required of the system. That is why I urge you to think about this in terms of the consumer that we're sent here to protect and vote yes on Senate Bill 93. Thank you.
Majority Leader Fenberg. Minority Leader Holbert.
Thank you, Madam Chair. I didn't go to law school once or twice. I kind of wish I had at this point in my life, but I struggle with some of the provisions of this bill. For instance, on page 12, starting in line 5, it says that the protection of confidential information, the disclosure requirements in sections 1322, 212, parentheses 1.5, end parentheses, and 1322, 807, do not require the disclosure of any information subject to the attorney-client privilege or other recognized privilege or immunity from disclosure. Okay, to a layperson, non-attorney, that sounds like a good standard. But if I go on to page 13, disclosure by arbitrator. Now, existing statute says, before accepting an appointment, an individual who is requested to serve as an arbitrator after making a reasonable inquiry, now we get into some new wording in capital letters, in accordance with the process set forth in subsection 1.5b of this section. Okay, well, let's go look at that. Starting at 1.5a, in addition to the information required by subsection 1 of this section, an individual who is requested to serve as an arbitrator in any consumer or employment dispute governed by Part A of this Article 22, shall, before agreeing to serve as an arbitrator of the dispute. So if I'm a consumer, I want to have an arbitrator, before he or she can be my arbitrator, he or she has to disclose to all parties, not just to me as a party, but to all parties, to the agreement to arbitrate and arbitration proceeding, and to any other arbitrators, any information that a reasonable person would consider likely to affect the impartiality of the arbitrator in the consumer or employment arbitration proceeding, to the extent such information can be ascertained by reasonable efforts, including any pecuniary or financial interest the proposed arbitrator may have relating to the issues in the arbitration or the outcome of the arbitration, except for payment for arbitration or mediation services or reimbursement of costs, whether the proposed arbitrator has been paid an amount exceeding $500 for services by a party. Well, if the arbitrator is an attorney, would that be disclosed? And if he or she isn't an attorney, would he or she be required? Because payment between a client and an attorney, again, I'm not an attorney, but that seems like something that might be covered under attorney-client privilege. And if it does create a double standard, then I have a problem with that. An attorney in the arbitration, a law firm which an attorney in the arbitration is currently associated, or any of the parties' liability insurers. 3, any experience as an owner or employee of an entity or sole proprietorship engaged in the same or substantially similar industry as a party. Again, if the arbitrator is an attorney, would he or she not have to disclose that, or would they? It seems like that might be also something potentially covered under attorney-client privilege. And if, again, this creates a double standard for attorneys versus non-attorneys, then that is a concern for me. 4, any experience as an attorney, consultant, independent contractor, expert witness, agent, or other representative of and for an entity or sole proprietorship engaged in the same or substantially similar industry as a non-consumer or employer party. That seems to be directly at attorney-client privilege. If attorneys would say, no, I don't have to disclose this information because I'm an attorney and I have that attorney-client privilege, but non-attorneys would be required to, that seems like a double standard. 5, any experience as a representative, attorney, independent contractor, expert witness, agent, or other similar representative of and for consumers or employees similarly situated to a consumer or employee party. I'm confused. I don't even understand what that means, but again, I see that there seems to be a double standard, that attorneys would say, no, I don't disclose this information because I'm an attorney and I have attorney-client privilege with some of those entities, or as having performed part of one or more of those roles. Any current or former relationship with any liability or other insurer that the proposed arbitrator knows may provide coverage for the award, that also seems to create at least a double standard, if not a triple standard, and a non-attorney, attorney, and then potentially an attorney who has represented an insurance company that might, or another company that might provide coverage, some or all of the coverage for the award. 7, a list of all the arbitrations identified by party names that the proposed arbitrator has participated in. Well, again, if the arbitrator is an attorney, couldn't he or she say, no, all of that information is covered under attorney-client privilege? And this is where I really start to get concerned that non-attorney arbitrators are, by this bill, it seems to me like they have a huge hurdle to get over just to continue to be an arbitrator, or someone who wants to begin to be an arbitrator who isn't an attorney. If my reading is correct, there is this huge double standard here. of disclosure that would be almost unlimited. How do you collect all this information and keep it up to date for each potential customer? Picking up again on line 3, page 15, names that the proposed arbitrator has participated in as an arbitrator during the prior 5 years, modified if necessary to protect reasonable privacy concerns of a consumer or employee party or enforceable confidentiality agreements. So if I'm not disclosing information and I'm not an attorney, could I be challenged legally if I don't disclose this information? Wouldn't I need to produce those confidential documents to prove my innocence? And if I have to prove that innocence by providing those confidential documents, they don't really seem confidential anymore. 8, the names of the parties or to arbitrations in which the proposed arbitrator has participated as an arbitrator during the past 5 years and their attorneys. Okay, so if I'm an attorney arbitrator, I'm giving information about other attorneys I've worked with, I guess. Maybe they're not clients and not covered under attorney-client privilege, but that also seems problematic. And copies of any decisions and rewards rendered. Again, I'm not an attorney, but could any of those decisions or awards be confidential under court order? It seems likely to me as a non-attorney. Maybe an attorney can tell me. And any copies of any decisions and awards rendered, modified if necessary to protect reasonable privacy concerns of a consumer or employee party or enforceable confidentiality agreements. B, 8B, to aid the proposed arbitrator of a consumer, to aid a proposed arbitrator. I find that somewhat ironic. It seems like all of this is to hinder a proposed arbitrator, and I would guess to the benefit of attorneys, of a consumer or employment dispute governed by Part 8 of this Article 22 and disclosing information that must be disclosed pursuant to subsection 1.5a of this section. The proposed arbitrator, 1, may ask either party about the disputed material, factual, and legal issues to be resolved in the arbitration. Okay. So the proposed arbitrator seems to be able to have legal standing here to ask an attorney about things that are covered under attorney-client privilege, and that's confusing to me. 2, may ask either party about the party's business or occupation, counsel, agents, representatives, employees, independent contractors, and insurers to the extent such persons or entities may have knowledge relevant to a claim or defense or may provide potential insurance coverage for an award. And 3, may respond to inquiries from a party or its counsel designated to determine his or her suitability and availability for the appointment. In any such dialogue, the prospective arbitrator may receive information from a party, its counsel disclosing the general nature of this dispute, but should not permit the party or its counsel to discuss the merits of the case. Again, thank you, Madam Chair, for your patience, but as I read from page 13 of the bill on line 6 through page 16 on line 3, I find reason to be greatly concerned about Senate Bill 93. It seems to be perfect for attorneys and completely biased against arbitrators, especially those who are not attorneys. And as a non-attorney, I've not been in an arbitration, but this seems like a recipe for higher cost and less opportunity for consumers, and yet it's supposed to be for the benefit of people who are looking for fairness in arbitration. It seems to be completely biased against we the people and for attorneys. So maybe I'm wrong, and thank you, Madam Chair. I'd love to hear some perspective as to why I might be wrong. But for now, I ask for a no vote on Senate Bill 93.
Majority Leader Fenberg.
Thank you, Madam Chair. I would never suggest that the good senator from Douglas County is wrong. but happy birthday nonetheless. Thank you, Madam Chair. Couple of thoughts, and then we do have a handful of amendments on some of the issues that have been discussed. There were some comments that the disclosure requirements are so burdensome that this would basically put arbitrators out of business and it wouldn't be an option in the state of Colorado. And a couple of the, maybe that wasn't stated exactly correctly, but that was what I heard, so I'm sure I'll be corrected. But that it's a very burdensome disclosure process. And one of the examples was you have to disclose this stuff quarterly. That's 4 times a year. Last time I checked. That is crazy. Why would we require professionals to report on what they are doing 4 times a year? To me, that's pretty reasonable. And in fact, the big arbitration companies already do that in the other states that require them to do it. And they often disclose things that they're not even required to disclose in Colorado since this bill hasn't passed yet, but they just do it because it's one spreadsheet and they'd rather just upload it once. So it's not all that burdensome. If you are an arbitrator, I'm guessing you keep records of the cases you were an arbitrator for. And this simply is saying that you have to keep those records and update them on a website, which is not very difficult. I think you can get a website for $9.99 these days. The other, one of the other issues that we were told is a burden is to keep these records for 5 years. If you're an attorney, I'm guessing you keep records of the cases you worked on for at least 5 years. If you're an arbitrator, I would think you would do the same thing. 5 years is not a crazy amount of time to keep records if this is what you do for a living and this is your professional career. And the reason behind that is not just to be a burden. We are not requiring these disclosures in this bill because we want to just stick it to the arbitrator and make it difficult. It's because that is actually how consumers and employees can ensure they are protected. For instance, in the employee-employer relationship, and it was mentioned that there's a level playing field between those two, I would argue that is not true. That is why we have labor unions. That is why we have protections for workers in the state of Colorado, because it is often not a level playing field. And when you are offered a job, when that is your living, and it will mean whether you can put food on the table or not for your family, you don't really have a ton of leverage when you're signing that contract to say, I'll take the job as long as you take this arbitration clause out of it. Oftentimes the employer will say, take it or leave it. We're not changing the contract. But the reason why it's important to require disclosure of this sort that we're discussing here this morning is because it does provide evidence of patterns of behavior or of abuse. For instance, if you're an employee and there's a sexual harassment complaint that you want to give, or if you're a prospective employee, if there's forced arbitration and you have to go through forced arbitration for that dispute because you signed that contract when you took the job, there's a good chance no one will ever find out about that abuse or that harassment. Maybe on one occasion we could say, maybe that's fair. Maybe there's a misunderstanding. But if that employer is going to the same arbitrator every single time that there is this type of complaint, and it involves the same people at this place of employment every time, I think we would all say that that secrecy actually puts future people in danger. And that is why disclosure is important. It's because it takes things that are otherwise potentially a secret and put under the rug, and it puts them out into the public realm so people can feel that they can be protected, and if there are others in similar situations, they can seek appropriate recourse. If they think they are alone, it is probably more difficult, and you think it's a one-off instance. If they go to this website and see that there are 30 other women that have settled sexual harassment complaints with the same individual, I think that's helpful information to know. I will offer one amendment to get us started. I think the senator from Lafayette has several others, but for now we'll start with a relatively simple one.
There is an amendment on the desk. Will the clerk please read Amendment L013?
Amendment L013.
Majority Leader Fenberg.
Thank you, Madam Chair. I move L013. Members, this is a simple amendment that I think addresses an unintended consequence that was in this bill that I think this is a very reasonable fix too. So previously the bill said that you couldn't have a arbitration, you couldn't require that the arbitration happens more than 100 miles away from where that consumer or that employee resides. We realize that it probably seems unnecessary to require someone to go more than 100 miles away to go through an arbitration process, and sometimes that length, that distance is used to discourage them from even participating or challenging the situation. We changed that to say that it just simply has to be in Colorado. So this addresses one of the concerns from several folks, such as the ski industry, that says if there's a dispute from someone out of state, they don't have to be within 100 miles of where that tourist may have come from. Maybe it's across the country, but they just simply have to do it within the state of Colorado. I ask for an aye vote on L013.
Is there any further discussion on Amendment L0013? Senator Lundeen.
Thank you. We are making progress. Almost feels like an arbitration. I hope we can keep the industry alive.
Is there any further discussion on Amendment L0013? Seeing none, the motion before the body is the adoption of Amendment L013. All those in favor say aye. No. Seeing that we are all in favor, that amendment is adopted. Senator Foote.
Thank you, Madam Chair. So I mentioned before, and I'll just reiterate if there were some folks that weren't in at the moment that I mentioned this, and I think that you've seen also from the Majority Leader's amendment that was adopted unanimously, that we have been talking with many parties and offering to any party that has concerns to bring us language that we would consider to for a possible amendment. And so there are a number of amendments that I'll be offering as well that are along those lines. And we're doing this even though we know that I think many of the opponents will still remain. And we've been in dialogue with them and trying to make sure that we pass a good solid bill. And the opponents are still, some at least, are still going to be the opponents, and that's their right to do, of course. But we are trying to work with folks to make it a good solid bill. One thing I want to mention before offering my first amendment is this. I think that I should say, for those that know about our court system, either through their work here or having worked in it or been involved with it in some way or another, it's pretty straightforward. You have a dispute, you go to the judge is supposed to be neutral, the judge can find for you or against you or some combination thereof. And we generally trust the court system because we trust the fact that the judge that has been appointed and has to be retained by a vote is a neutral magistrate, as it's sometimes termed. What we're looking to do in this bill is to make sure that the arbitration process can have a similar reputation, that the arbitration process and the arbitrator that is appointed will be seen by both sides as being fair and giving a fair shake. And right now, under some mandatory arbitration clauses, the one party, in this case an employer, for example, or a company, can choose the arbitrator, can choose the venue, can choose and actually usually does pay the arbitrator and has access to all the information about how that arbitrator has ruled in the past, and the other side doesn't have any of that choice or any of that information. So part of what we're trying to do is make sure that the arbitrator that is selected is an arbitrator that both sides can find to be impartial and give them a fair shake. And I want to emphasize that if that agreement is made up front, if it turns out that both sides agree to an arbitrator, then there's no basis for objection down the road. There's no basis for litigation or going to the court to seek redress down the road. If both sides agree to an arbitrator up front, then that objection is waived. And that's part of what I want to make clear in L011. So I'll move L011.
There is an amendment on the desk. Will the clerk please read Amendment L011?
Amendment L011, Senate Bill 93.
Senator Foote, now you can move it
I move L011.
to the amendment.
All right, thank you, Madam Chair. So just to give a little bit of background for a little more context about this amendment. You know that part of the bill deals with what would be considered to be evidently partial in the context of an arbitrator that is selected. A judge at the end of the process, now under the current law, this has been in law for quite some time, there can be an objection after the judgment is rendered by the arbitrator. The party that's on the losing end of that can object to the court and say, well, we think this arbitrator was partial. So that exists in law now, and part of the bill further defines exactly what it means to be partial. I think we've gone over that a little bit. But one thing that was brought up to me was, okay, well, let's say that one party is proposing an arbitrator, the next party objects to that arbitrator, and then the other party says, okay, we'll propose another one, and then the other party objects, and so on down the line. It's continuous objections in order to try to preserve the ability to go through litigation and claim that the arbitrator was evidently partial. So endless objections, which could lead to litigation, was the summary of that particular critique. And so this amendment would actually make it so the endless objections could not occur. If one party objects to an arbitrator that's proposed, the other party can actually seek redress with the court and have the court intervene, and the court could suggest or appoint an arbitrator itself. This is also through something that currently exists in the arbitration statute, where the court can intervene and the court can address concerns about the process in certain ways. And so we're just piggybacking off what's already in statute and making it clear that one party cannot continuously object to an arbitrator. And the point is, of course, to incentivize the parties agreeing on an arbitrator so they can go forward and have their arbitration, and both parties feel like they got a fair shake. So I'm asking for an aye vote on L011.
The motion for the body is the adoption of L001. All those in favor say aye. Those opposed, no. The ayes have it, and the body will adopt Amendment L011. Senator Foote.
Thank you, Madam Chair.
There is an amendment on the desk. Will the clerk please read Amendment L012?
Amendment L012, Senate Bill 93 by Senator Foote, amendment printed bill page 19.
Senator Foote.
Thank you, Madam Chair. I move L012.
To the amendment.
Thank you, Madam Chair. L012 actually covers some familiar ground that we dealt with in the First Amendment to this bill, which dealt with the venue issue about the state of Colorado. And that amendment passed unanimously, as was noted. What we do here is we actually strike a particular section of that venue part of the bill, and we strike the word entities because it was brought to our attention that entities can include entities and organizations that actually do arbitration. So if you have an organization like AAA, for example, they have many arbitrators, and the bill as written would exclude one party from being able to just work through one entity for arbitration. And so we want to make sure that that party can continue to work through that arbitration contractor. But ultimately, of course, we want to make sure the arbitrator that is assigned would be fair and impartial. And so we're asking for an aye vote on L012.
Is there any further discussion on Amendment L012? Seeing none, the motion before the body is the adoption of Amendment L012. All those in favor say aye. Those opposed, no. The ayes have it, and the amendment is adopted. Senator Foote.
Thank you, Madam Chair.
There is an amendment on the desk. Will the clerk please read Amendment L014?
Amendment L014 to Senate Bill 93.
Senator Foote,
Thank you, Madam Chair. I move L014.
to the amendment.
Thank you, Madam Chair. L014 also was brought to us by a party that is still going to oppose the bill. However, we think it makes sense, and we'll ask the body to adopt it. It addresses the confidentiality section. It's entitled Protection for Confidential Information. And we want to make sure that if there actually turns out to be a settlement, not a judgment, but a settlement before the judgment in arbitration, and both parties agree that that settlement of specific conditions or specific requirements or conditions of that settlement, if both parties agree that that should be confidential, then those are part of the confidentiality and the protection of confidential information section that's already in the bill. So we just wanted to make that clear to address that particular concern and ask for your support on L014.
Is there any further discussion on Amendment L014? Seeing none, the motion for the body is the adoption of Amendment L014. All those in favor say aye. Those opposed, no. The ayes have it, and the amendment is adopted. Senator Foote. There is an amendment on the desk. Will the clerk please read the title to Amendment L022?
Amendment L022.
Senator Foote,
Thank you, Madam Chair. I move L022.
to the amendment.
Thank you, Madam Chair. L022 continues our focus on making sure this applies, that we are actually being clear this applies to the state of Colorado. And right now there's a section on page 18 that talks about employment as being a subject. We just want to make sure it's, again, employment in Colorado. We actually don't think that we would have jurisdiction over employment in other states, but just to make it clear, and again, based on some feedback we received, we'd like to have this amendment passed to clarify that in the bill. So that's L022, and we ask for your support.
Is there any further discussion on Amendment L022? Senator Lundin.
Thank you very much, Madam Chair. Appreciate the amendment. I think it achieves some clarity around the fact that we're talking about employment in Colorado. I just want to be clear that this doesn't give us relief from the challenges that AB 51 out in California is having in the courts. The fact that we may still be afoul of the Federal Arbitration Act. So just be clear, we're making headway here, but this does not get us to resolution, even specifically with regard to many of the employment elements. So I appreciate the amendment, but want to be clear, we've got a long way to travel still.
Senator Foote.
Thank you, Madam Chair. So I want to take just a moment to address this concern, the preemption concern. Of course, we're aware of the preemption issue. We're aware of the California law. This bill does not resemble the California law, and we certainly have worked around that. Actually, if this bill represents or resembles any other state's law, it comes from particularly the transparency section. Many of the provisions come from what's already been in law in the state of Montana and the state of Maryland for up to a decade. And it's worked just fine for them. It has not been preempted by federal law. And so if you want to take a look at this bill with other states in mind, take a look at those states and their histories, and that's exactly what we've done. So the federal preemption issue is something that we, of course, had in mind and we took a look at very closely. And if the California law becomes a topic of discussion, that's fine. But I'll just tell you that we really didn't do too much from the California law. It's a totally different package, that law is.
Further discussion? Senator Williams. Further discussion on Amendment L022? Seeing none, the motion before the body is the adoption of Amendment L022 to Senate Bill 93. All those in favor of this amendment say aye. Aye. Opposed, no. The ayes have it. Amendment L022 is adopted. To the bill. Senator Williams.
Thank you, Madam Chair. We have an amendment.
There is an amendment at the desk. Will the clerk please read amendment number L020?
Amendment L020, Amendment 93% of vote amendment on bill page 20, strike lines 2 through
Senator
3.
Williams.
Thank you, Madam Chair. I move L020.
Is there any discussion? Can you,
Madam Chair, what we have here on L020 is that this amendment will remove the designating the use of deceptive trade practices. We already have a remedy in law, and we have the correct remedy on Riley versus Korholtz, and we believe that this is not necessary since that this provision is already in law and it has worked for over 50 years. So I ask you for an aye vote.
further discussion? Senator Foote.
Thank you, Madam Chair. We consider this a friendly amendment. Ask for its adoption.
Further discussion on this amendment? Seeing none, the motion is the adoption of Amendment L020. All those in favor say aye.
Aye.
All those opposed, no. The ayes have it. The amendment is adopted. There is an amendment at the desk. Will the clerk please read the title to Amendment L021?
Amendment L021, Amendment 93% of vote amendment on bill page 9, strike lines.
Senator Williams.
Thank you, Madam Chair. And members, I move L021. And this is about the public disclosure requirements. And I really don't understand why the general public needs to be involved in conversations between the parties. I think the parties alone should have access to this information. It will allow the services provider to do a single cumulative report, and again, it strikes the word public and keeps this between the parties. They can collect information, but they cannot publish that information, and so I'll ask you for an aye vote.
Further discussion? Senator Foote.
Thank you, Madam Chair. We do consider this also a friendly amendment, and just to point out again, the conditions that are attached to the disclosure, even if this amendment passes, it's private instead of public. Those conditions have been tried and true and tested in other states like Montana and Maryland, and so we're not just making this up out of whole cloth. It's something that's been vetted, it's been done, and certainly arbitrators in those states have shown that they can comply with it, and it's not unduly burdensome, so we ask for an aye vote on the amendment.
Thank you. Any further discussion? Seeing none, the motion is the adoption of Amendment L021. All those in favor say aye. Aye. Those opposed, no. The ayes have it. The amendment is adopted. To the bill. Senator Zenzinger.
Thank you, Madam Chair. Members, I am bringing forward an amendment here, and so I'll go ahead and put it into the desk.
There is an amendment on the desk. Will the clerk please read Amendment L010?
Amendment L010, Ms.
Senator Zenzinger.
Thank you, Madam Chair. I move Amendment L010.
To the amendment. Is there any discussion?
Members, I have some reservations about the bill's impact on the issue of construction defects. I know that that is a very contentious issue down here at the Capitol that we've been working on over the last few years. What this amendment does is it clarifies that nothing in this act is intended to approve, disapprove, modify, or overrule the Villaggio Inverness Residential Condo Association versus Metro Homes decision, and that is all it simply does. I ask for an aye vote.
Further discussion? Senator Lundin.
Thank you very much, Madam Chair. Appreciate so much this amendment. As we all know, it's in the legislative declaration. It establishes that it is the sense of, it is the desire of, it is the concern of this body that it be such But I want to call out and be clear to everybody that when we say this is what it is, but then we write things into law that may cause, intended or unintended, a different result, the fact is the law is what drives human behavior. The law is what drives all of the elements of interaction. So this is important that we say this. Yes, I rise in support of the amendment. However, it's really important we all acknowledge and know that the unintended consequences that may in fact do exactly the opposite of what we're saying we want to have happen still, in my opinion, remain in the bill. And that is, there is violence, I believe, to affordable housing in Colorado that remains in the bill as still constructed. So I just want to call out, good amendment. It's important that we say this is what we care about, this is what we want, but it's very, very important that we also acknowledge the laws we're putting in place, the rules that will come forth from that, and the human behaviors that are inescapable may in fact redound to the damage of affordable housing in Colorado still by force of this particular bill as amended at this point.
Further discussion? Senator Foote.
Thank you, Madam Chair. First of all, we consider this a friendly amendment, and I want to explain a little bit more about this. One of the, as I've mentioned several times, we've been continually talking to opponents of this bill. One of the arguments that I very much disagree with, and I think is not on point at all, is that this bill undermines or overrules or overturns the Bellagio case. It does not. This bill has nothing to do with the Bellagio case. Bellagio case held two things, none of which are located in this bill. It held that consent to amend agreements were valid. It also held that mandatory arbitration clauses are still enforceable under the Colorado Consumer Protection Act. And if we really want to go down this rat hole on the Bellagio case, I'm happy to do that. In fact, I have the case right here, and I have the holding highlighted in green for anyone that wants to take a look at it. And perhaps the good senator from Colorado Springs will come up and tell us exactly how this bill relates to the Bellagio case and the holding of the Bellagio case. Nevertheless, I think the amendment is appropriate because we're just putting it out there in the bill what we've been saying all along since the bill was introduced, and then I'm saying yet again, this bill has nothing to do with the Bellagio case. We ask for your aye vote on the amendment.
Further discussion? Senator Gardner.
Thank you, Madam Chair. I just wanted to be recognized. Thank you.
Further discussion on Amendment L010? Seeing none, the motion is the adoption of Amendment L010. All those in favor say aye. Aye. Opposed, no. The ayes have it. The amendment is adopted. There is an amendment at the desk. Will the clerk please read the title to, will the clerk please read Amendment L025?
Amendment L025, Senate Bill 93 by Senator Fenberg, Amendment Bill page 18, line 8.
Majority Leader Fenberg.
Thank you, Madam Chair. I move L025.
Discussion?
Thank you, Madam Chair. Members, this just further narrows the scope for the standard form contract piece of the bill, and it simply strikes goods or services, and so therefore that section of the bill does not apply to contracts that deal with goods or services.
Is there any further discussion on Amendment L025? Seeing none, the motion for the body is the adoption of Amendment L025. All those in favor say aye. Those opposed, no. The ayes have it, and the amendment is adopted. Is there any further discussion on Senate Bill 93? Senator Moreno. There is an amendment on the desk. Will the clerk please read Amendment L024?
Amendment L024 to Senate Bill 93 by Senator Moreno. Amendment printed bill page 16, strike line 6 and substitute document.
Senator Moreno.
Thank you, Madam Chair. I move Amendment L024.
To the amendment.
Thank you, Madam Chair. Colleagues, I read the bill. There's a lot of good things in this bill to make sure that folks are impartial and that all parties are treated fairly. I am taken aback a little bit by the extremely prescriptive nature of the bill. There are a lot of requirements in here that are just, you don't see as common as in state law, including that the disclosures that are, some of the disclosures that are required be given to the parties in a separate document in at least 14-point type. Is that something that we really want in state law? And so this amendment would simply strike the 14-point type and say that it has to be provided in a separate document. I ask for an vote.
Is there any further discussion on Amendment L024? Majority Leader Fenberg.
Thank you, Madam Chair. I just want folks to know that this is the art of compromise, because originally it was 19-point font and in Times Roman. And this is the compromised version. But with that said, I do think we accept this as a friendly amendment.
Is there any further discussion? Senator Gardner.
Thank you, Madam Chair. Well, I hope it'll be at least in 10-point so that I don't have to have my eyes checked again, because 6-point gets pretty small. So we could ask for bold print. We could ask for italics, but I appreciate this amendment and we'll vote aye.
Is there any further discussion? Seeing none, the motion before the body is the adoption of Amendment L024. All those in favor? Are there any opposed? Seeing none, Amendment L024 is adopted. To the bill, is there any further discussion on Senate Bill 93? Senator Lundin.
Thank you very much, Madam Chair. And colleagues, I appreciate the efforts that have been made here. Obviously, we have this beautiful process where a bill gets 3 readings in each house, and this is the second reading, which means we've got another opportunity to consider, digest what we've received and worked through today, and then perhaps engage in that matter again tomorrow. I want to make clear for the record that we still have an enormous body of very prescriptive, and I think we were kind of teasing about the last amendment that said 14-point type. Really? Is it Garamendi? Is it italic? Is it Times New Roman? The level of prescription in this bill is in alignment, quite frankly, with that which we just struck from the bill. There is so much prescription. I still have significant concerns about the burden of disclosure placed upon the folks in the arbitration industry. And think of it this way. You're a senator. There's a certain amount of your work, doggone it, that we just need to report. And we do. We have a journal. And it all gets bound in a beautiful bound book at the end of the session that says, here is the record of the source documents of Colorado. Senator thus and such voted this way on this particular bill. That's material. That's important. We need to know. The bill passed with a vote of X to Y. But should that record include that the good senator from, we'll say, Douglas County, who's a very thoughtful individual, he considered an amendment L002, and then he removed that amendment without having offered it, in fact, because as part of the dialogue, that amendment was no longer a necessary part. The bill, the point I'm trying to make here, as we go through our business of legislating, we take many actions that are part of how we get to the important result that should be reported. But if we try to report every single one of those actions, the information becomes so cumbersome as to become meaningless. And that's kind of the burden that this bill places on arbitrators. They have to, under this, as written, they have to report quarterly up on a website that they have to keep updated. And quite frankly, if your business is the business of creating websites and updating websites, good on you. A quarterly update's no big deal. But if your business is otherwise it consumes your time elsewhere, and you have to back up and take an administrative action that really is not central to your business in order to comply with some sort of onerous reporting burden that takes you away from doing the service that you try to provide to people, it's moving you in the wrong direction. You have to report under this bill the nature of any disposition that you were involved in, the dispute, if known, identified as one of the following: withdrawal, abandonment, settlement. That's kind of a vote. Okay, that seems reasonable. But you have to identify if there was an award after the hearing, there was an award without the hearing, a default, a dismissal without hearing. You have to report if a matter was administered in a hearing and whether the hearing was, get this, you need to report on your website whether the hearing was held in person, by telephone, video conference, or by document. And I haven't seen this amended out. If it's amended out, I missed the amendment that did it. You must further report things like the amount of the claim, whether equitable relief was requested or awarded. Think about this. You have to re-litigate, to use a legal term in a space where we're trying to avoid legal action. You have to re-report every minute movement of every single thing you've done with regard to your business in order to comply with this. So I will not belabor further, even though the bill does belabor further the people trying to remain in the arbitration business. I will not burn your ears with more words on this, but I will simply make the case, and if you haven't read it yet, pull out the bill, pages 9, 10, 11, 12, and think, put yourself in the shoes of somebody who's trying to do a business of helping people resolve conflicts, and think about how much time it would take you to do all of this, and then think about whether or not that has so much distraction for you for your participation in that business that you might just think about doing other things with your time. So I am grateful for the conversations we've had, the progress we have made, but I remain in opposition to this bill, and quite frankly, I remain concerned that this bill will hamstring or in fact perhaps disrupt in a way that is not beneficial for the people of Colorado, the arbitration industry, and I remain in firm opposition to Senate Bill 93. Thank you, Madam Chair.
Senator Lee.
Thank you, Madam Chair, and maybe my comments will persuade my colleague from El Paso County to change his view. I have no doubt that he will be listening attentively and is open-minded about it, as he always is. I'm a big supporter of arbitration. Having lawyered for almost 4 decades, I've become very familiar with the litigation process and the court process, and I know it to be burdensome, tiresome, expensive, and can last for long periods of time. However, the arbitration process is an expedited process designed to provide quicker justice. I'm very familiar with arbitration. I was a labor management lawyer early in my career and participated in over a dozen labor management arbitration cases arising out of a collective bargaining agreement. And a collectively bargained agreement is an agreement written between management and labor unions who have equal bargaining positions, and they set forth the terms of the arbitration and how the arbitration is conducted. And because of that equality of bargaining position, labor management arbitration agreements are inherently fair and are inherently appropriate the way they treat both parties to the arbitration. So I thank the sponsors for bringing this bill because it puts some of the guardrails around forced arbitration that exist in labor management arbitration. Some of the arguments that we've heard today, I think, are a little bit hyperbolic. In my view, as I've read this bill, it is pretty thoughtful, pretty measured, and pretty targeted in what it's attempting to accomplish. At a most fundamental level, it is requiring that the same ethical standards that are applied to lawyers and judges in litigation are applied to arbitrators in arbitration agreement. They're not allowed to have conflicts of interest. Who would want to have, as an arbitrator in a dispute, a person who has a vested interest in the dispute, or a person who is the arbitrator who actually works for the other party? The term used in this agreement is evident partiality. You don't want to have an arbitrator settling your dispute who is evidently, obviously partial to one side or the other. So it's reasonable to have these provisions in there. In addition, the bill requires disclosure. We've had amendments to clarify what those disclosures are, but it's really important for the parties to understand what the arbitrators have been doing in the past. In the arbitrations that I did under the Labor Management Act, we would receive information about the arbitrators, biographies about the arbitrators. We would receive information about the cases that they have been involved in. And each party, labor and management, I was on the management team at that point, would strike arbitrators who they viewed as being partial to the other side. And then you would come down, as the other senator from El Paso County described, to an arbitrator that both parties can agree with. So the disclosure that is required under this bill is similar to the disclosure that is provided under the American Arbitration Association, and it just gives the parties a fair shot to understand exactly what sorts of cases and what sort of rulings those arbitrators have been involved in. The third other reasonable provision of the bill are the provisions dealing with the standard form contracts. I think the dispelling of the notion that this impacts in any way Bellagio has been clarified, but quite frankly, it's necessary in an arbitration agreement to have provisions which are fair and reasonable to both parties. Don't make a party go out of state or travel hundreds of miles to attend it. Don't have a provision in the agreement that awards fees contrary to Colorado state law, and that's one of the provisions in the agreement. And don't allow one party to select the arbitrator, and don't allow provisions to be put in that arbitration agreement which everyone knows are unfair. So those provisions are removed. The reason we need a bill for this sort is to ensure that both parties have a fair shot. And in forced arbitration, there is oftentimes a bias in favor of the person who wrote the agreement, which is usually a big corporation, and you and I signed lots of consumer contracts which have these forced arbitration provisions in them. But for example, in forced arbitration agreements with Kaiser, there were over 400 cases arbitrated. The consumers won 12. You would think in a fair arbitration system with 400 cases, there would be a greater proximity of victories by both sides. In United Healthcare arbitrations, again, under forced arbitration agreements, there were, as we understand it, 262 arbitrations, and the consumers won 4. Ladies and gentlemen, I submit that with that inequality, there's got to be presumptively something wrong with that process. So I would suggest that what we're trying to do is provide a mechanism to provide that arbitration is more fair, more just, by shining the light of disclosure on it and requiring equitable standards. And I think those are reasonable things to do, so I would urge support of this bill. Thank you.
Is there any further discussion? Senator Gardner.
Thank you, Madam Chair, and I appreciate the comments of the senator from El Paso County and from across the aisle. If this bill, as originally drafted, was narrowed in the way that the good senator from El Paso County and across the aisle suggested, I would have far less to say about it. And I thank the sponsor and others for offering amendments that do, in fact, narrow this bill in ways that, frankly, we haven't completely had a chance to digest. My sense is that we are not quite there as far as ensuring that this bill gets to the question of when is an agreement to arbitrate a contract of adhesion, in essence. That is a contract on which there's no real choice whatsoever. And again, in my initial remarks, I said if that was what this was about or the way it was focused, I get it. Now, I don't know what the sponsor's intent is. We can only take the intent of the bill from the words that are on the page. As with so many other things, I think there's probably in the General Assembly 100 different intents, maybe more than that. I appreciate the narrowing of the application of this bill. I appreciate the legislative declaration concerning Villaggio, but I want to study it a good deal more carefully between now and third reading, and we'll have some comments about that once I've had a chance to study the amendments to ensure that if in fact, as the sponsor says and as the amendment says, that it does not apply to in any way, it is not intended in any way to upset the Villaggio decision, that is the case. And we'll hope that there will be assurances on the record of that during third reading. With that, members, I want to again express my appreciation to the sponsors and those who brought the amendments for listening. However, I think we probably have a further way to go on this to ensure that what we're dealing with is what the start of this problem was, which is true consumer contracts and contracts of completely unequal bargaining power. Thank you.
Senator Lundin.
Thank you very much, Madam Chair. And I thank the bill sponsors for the work they put in today on narrowing. I would like to see us go further. In fact, I would like to see us get to the point that the good senator from El Paso County and across the aisle said. He essentially identified that arbitrators who are attorneys currently must comply with code of conduct that is conduct for attorneys and the code of judicial conduct. And these codes are very clear and they're extensive and they're enforceable. An amendment that was suggested but not offered would have brought us to exactly that point. And that is, well, let's just use that instead of all of these other new ideas about disclosure and prohibitions of ability to interact and so forth. Let's just take those well understood codes of conduct, make them enforceable by the Bar Association on attorneys, and for those who are not attorneys but in the arbitration business, make them then enforceable by the association that has authority over those in the arbitration. So that sort of progress would be the sort of progress that gets us to a meaningful improvement on the bill. So I appreciate the progress we've made. Still, I believe we have a long way to go. And I want to be clear, because I am not an attorney. I am a recovering member of the House Judiciary Committee, but I'm not an attorney. My concern isn't about the nuance, the legalities, the give and take of the case law that is referred to in this well with regard to this issue as Bellagio. My concern is around human behavior, human nature, and what will happen to create instability for insurers, therefore increased cost for insurers, therefore increased cost for developers and builders, therefore a pinch on affordable housing. It's human behavior I'm talking about, not the fiat of statute, the legislative fiat of statute, or the case law known as Bellagio. My concern is we're doing something here that I think will change the way people interact, that will in fact put a clamp on this improvement we have been having with regard to affordability in housing in Colorado. So I wanted to be clear about that. It's not in fact the case law I'm talking about. It's human behavior, insurance, cost of building, and cost of housing. Again, I conclude by saying thank you to the sponsors for the work they've done. It is my perspective that we do need to digest what we did achieve today, and based on my limited understanding in the moment, we still have quite a ways to go. Thank you very much, Madam Chair.
Is there any further discussion on Senate Bill 93? Seeing none, the motion before the body is the adoption of Senate Bill 93. All those in favor say aye. Aye. Those opposed, no. The bill is adopted. Majority Leader Fenberg.
Thank you, Madam Chair. I move the committee rise and report.
The motion before the body is to rise and report. All of those in favor say aye. Those opposed, no. The motion is adopted. We will rise and report.
The Senate will come to order. Senator Zenzinger.
Thank you, Mr. President. The committee has considered a very interesting bill. Will the clerk please read the report?
Mr. President, your committee will always lead reports that in consideration of the following attached bills being second reading, there will make following recommendations. Number 1, Senate Bill 93 is amended to pass second reading order, raise place calendar for third reading and final passage.
Senator Zenzinger.
Thank you, Mr. President. I move the report.
The motion is for the adoption of the committee of the whole report. Are there any no votes? Senator Sonnenberg. With a vote of 32 ayes, 1 no vote, 0 absent, and 2 excused, the committee of the whole report is adopted. Senate Bill 093, as amended, passed on second reading, ordered engrossed and placed on the calendar for third reading and final passage. Announcements. Committee reports.
February 5th, 2020, Committee on State Veterans and Military Affairs, African Service Marines Committee following Senate Bill 75 be postponed indefinitely. February 5th, 2020, Committee on State Veterans and Military Affairs, African Service Marines Committee following Senate Bill 98 be postponed indefinitely. February 5th, 2020, Committee on State Veterans and Military Affairs, African Service Marines Committee following Senate Bill 122 be referred favorably to Committee on Appropriations. February 5th, 2020, Committee on State Veterans and Military Affairs, African Service Marines Committee following House Bill 1021 be amended as follows. That's amended be referred to committee hold a favorable recommendation. Recommendation be placed on the consent calendar. February 5th, 2020. The Committee on State Veterans and Military Affairs has had on consideration and had a hearing on the following appointments. Recommends appointments be placed on the consent calendar and confirmed. Members of the Board of Commissioners of Veterans Community Living Centers effective July 1st, 2019 for terms expiring July 1st, 2023. Richard Edward Young of Denver, Colorado, to serve as a veteran in Democrat, reappointed William Lewis Robinson of Castle Rock, Colorado, to serve as a veteran designee of State Board of Veterans Affairs and as an unaffiliated, reappointed Carolyn May Roll of Bush, Colorado, to serve as a member with expertise in nursing home operations, who is a nursing home administrator at the time of appointment, who is experienced in the field of financial operations of a nursing home as a Republican, reappointed for a term expiring July 1st, 2023, Scott James Bartlett of Woodland, Colorado, Woodland Park, Colorado, the state long-term ombudsman, and occasioned by the resignation of Ann Kerr Meyer of Evergreen, Colorado, appointed February 5th, 2020, Committee on Business, Labor, and Technology, has had consideration. I had hearing on the following appointments. The recommends appointment be placed on consent calendar confirmed. Member of the Uninsured Employee Board for effective September 1st, 2019, for a term expiring September 1st, 2022, Roger Allen Hayes of Aurora, Colorado, to serve as a representative of employers, reappointed February 5th, 2020, Committee on Business, Labor, Technology, after consideration, Mayor's Committee following Senate Bill 53 be postponed indefinitely. February 5th, 2020, Committee on Judiciary, after consideration, Mayor's Committee following Senate Bill 64 be referred to committee to hold the favorable recommendation. February 5th, 2020, Committee on Judiciary, after consideration, Mayor's Committee following Senate Bill 102 be amended as follows. As amended, be referred to committee to hold the favorable recommendation. Recommendation placed on the consent calendar. February 5th, 2020, Committee on Judiciary, after consideration, Mayor's Committee following Senate Bill 114 be referred to committee to hold the favorable recommendation. Recommendation placed on the consent calendar.
Announcements. Senator Donovan.
Thank you, Mr. President. May I request a moment of personal privilege?
Granted.
Thank you, Mr. President. Friends and colleagues, we are taking a moment today, both in the House and Senate, to recognize National Wear Red Day. And we're wearing red today just to signify the importance of the ongoing fight against heart disease and stroke. Cardiovascular diseases are the #1 killer of women in the U.S., and sadly, we kill one woman almost every 80 seconds with cardiovascular disease in the United States. So we wear red today just to remind women in this building, across Colorado and throughout the nation, to move a little bit more, eat a little bit smarter, manage their blood pressure to reduce the risk, and also to remind women that cardiovascular disease is one of our major threats that we don't often talk about being a threat for women. We have been doing this point of remembrance since I've been here in different ways, and I'm sure it preceded me by many years, but we continue to see heart health not always being something that women include in their kind of thoughtful self-assessment of what could challenge them being healthy. So when you see red today, we are showing support for women in the fight against heart disease. And if you have any women in your life, today would be a great opportunity to remind them to be heart healthy and take that into consideration. Thank you, colleagues, for pausing with me today. The House did the same thing, so today as a building, we're sending a message about National Red Wear Day, and hopefully we can save thousands of lives by increasing awareness. Thank you, Mr. President.
Senator Tate.
Thank you, Mr. President. Today is Economic Development Day at the Capitol, hosted by the Economic Development Corporation of Colorado. I don't know what the acronym stands for. Please join us for a legislative lunch at noon in the West Foyer. Come meet the economic development professionals and learn about legislation and issues. And these economic development professionals are mainly folks you know from your communities, your counties, and municipalities throughout the state of Colorado. Thank you.
Senator Gonzalez.
Thank you, Mr. President. I want to let folks know for the Senate Finance Committee that we will be meeting at 11:20 upon adjournment at SCR 357. Thank you.
Senator Winter.
Thank you, Mr. President. Transportation and Energy will be meeting 15 minutes after adjournment.
Senator Smallwood.
Thank you, Mr. President. I request a moment of personal privilege.
Granted.
Colleagues, I wanted to take a quick moment and not only make an introduction, but also offer you each an opportunity to hold the person responsible for my senatorial behavior here, as my father, retired Major Jim Smallwood Sr., is joining us today. So.
Senator Todd.
Thank you, Mr. President, and it's always It's always good to have another Kansan in the crowd, so another addition to the Sunflower Caucus. So Senate Education will be meeting in about 5 minutes after we are adjourned, and there will be a, oh no, excuse me, no, that's Finance this morning, I'm sorry. Education this afternoon. The order of the bills for education this afternoon will change in that Senate Bill 95 will go first, and then Senate Bill 81, and then we will go with Senate Bill 1, Senate Bill 123, and Senate Bill 14. So that order is just a little bit different, but the same bills will be heard. Thank you. Have a great rest of the day.
Mr. Minority Leader.
Thank you, Mr. President. 109 years ago today, the great Ronald Wilson Reagan was born, and 50 years later, I was. But there was another leader, majority leader, the late, great Ken Gordon, who would come down and point out that his birthday was the same as Ronald Reagan as well. And just want to remember his leadership in this chamber. He's not here to offer that memory anymore, but keep Ken Gordon and Ronald Reagan in your thoughts today. Thank you, Mr. President.
Senator Janal. Senator Janal and Senator Rankin. Senator Janal, go ahead.
Thank you, Mr. President, and I request a moment of personal privilege.
Granted.
Thank you. We have a tribute today for a very special person, and I would like to begin that tribute. It is to Lauren Collins, who served as a legislative aide from 2013 to 2016 for former state representatives Diane Mitch Bush and Millie Hamner, and then state representatives Joanne Janal, me, and Dave Young. Prior to serving in the Capitol, Lauren Collins worked as a wildland firefighter for the Larimer County Sheriff's Department. And in 2016, Lauren Collins enlisted in the United States Army, assigned to the 10th Mountain Division as an infantryman. This spring, Sergeant Collins and the soldiers of the 10th Mountain Division, 1st Brigade, 2nd Battalion, 22nd Infantry, Regiment HHC Scout Platoon will deploy to Afghanistan as part of Freedom Sentinel, the combat-oriented mission of NATO's Operation Resolute Support. Today, we wish Godspeed to Sergeant Collins and the soldiers of the 10th Mountain Division and extend our eternal gratitude to you and to your parents, William Collins and Veronica Olivas. May you return to us soon with honor and free from harm. Neil Saini Numene.
Senator Rankin.
Thank you, Mr. President. And I just want to speak for a moment on behalf of your coworkers and, of course, myself across the street on the Joint Budget Committee, where you were Representative Young's aide, and Treasurer Young is with us today, and I'm sure wants to join in this. We admire you, we thank you, and we look forward to staying in communications with you as you go forward. They tell me over across the street that you were known for making impressions of other folks. I suspect that might have been of the Joint Budget Committee members, but we never actually saw that. But we always enjoyed your company. And they tell me, or I knew from knowing you well, that your priorities were travel and serving your country, serving as a public servant. I'm not sure you had Afghanistan in mind when you talked about travel, but you certainly are doing the second priority, was serving your country. So we thank you, we admire you, and we love you.
Sergeant Collins, I too have known you for some time, and it's great to see you back and wish you Godspeed. So members, please give him an appropriate farewell and wonderful opportunity. Senator Janal.
Thank you, Mr. President. I first met Lauren Collins in 2013. He was my legislative aide, and then he moved into my campaign and was an excellent campaign manager. It was great to have someone who really took charge and went above and beyond to make sure I understood political issues. Lauren taught me a lot about politics and about policy. And one of the things I admire most about Lauren is his ability to speak and to listen to people of all ages and on any political issue that comes his way. He treated everyone, old or young, with respect. I'd always get compliments about Lauren, especially from my older constituents, and yes, from some younger constituents as well. His love for his family is another trait of Lauren's that I admire. He allowed me into his life and his wonderful family, his aunts and uncles and many cousins, as well as his mom, who is sitting there with his dad. His mom is with CSU Police Services, and his dad is a Fort Collins EMT paramedic, as well as his grandparents, who were not able to make it here from Fort Collins today. Lauren was my best aide, and I remember he worked hard all day, and he looked forward to all the evening events. He went to the ones I couldn't make, and he went to the ones I even did make. And one of his favorites, though, as I recall, was Ag Day steak dinner. I think it's still at the church on North Sherman, and those are some of the largest steaks I've ever seen in my life, and they're delicious. But he came in the office the next morning with this big smile, boasting they had finished off, I think it was six of those big steaks that evening for dinner, the evening before. And I believe it, because he did, I'm sure. But he loved working here at the Capitol, and he also wanted to serve our country. And his decision to enlist in the Army, it was weighted. It was weighted with staying here or moving on. And I told him the Capitol will always be here for him, and he needs to follow his heart. And he did. Lauren, the world is yours, and I know you will succeed in whatever you do. God be with you, and thank you for your service.
Senator Rankin.
Sergeant Collins, we would like to represent you with the plaque with this, this tribute that we read that was first presented to you in the House, but now you're in the Senate, so this is a big deal. We'd like to present this to you.
The Senate will stand in a recess so that we can welcome our guests.
Try to find a house. I'm gonna try to lose it and get a dog again. Walmart sneak out.
Is it under his desk? I think he took it to the lobby. Inhale all the helium before you don't business.
Martin.
I was ready to go across the street to get something.
She had to go get the Diet Pepsi.
Like to the store.
No.
To the store.
No, we need you there for lunch. Period.
We'll just do it tomorrow. Or the next day. That was your bold move. Huh? He left. He skipped out.
The Senate will come. The Senate will come back to order. Members, at the risk of doing a call of the Senate to escort the minority leader in for his birthday song, we will do it tomorrow, Mr. Majority Leader. Mr. Majority Leader.
Thank you, Mr. President. I move the Senate recess until noon today.
You have heard the motion. All those in favor say aye. All those opposed, no. The ayes have it, and the Senate will stand in a recess until 1200 hours today.